All right, thank you. I just want to start off by thanking Aurélien and also the Antitrust Law Journal for putting together this edition of the journal, as well as this symposium. In this paper, I only have one other slide than this. There you go. In this paper, I set forth a thesis that what I call the conflict paradigm of static versus dynamic competition is no longer reliable as a guide to better antitrust law enforcement and policy. And so I'm going to set forth just two initial starting points or definitions, assumptions, whatever you want to call them. A definition, what is this conflict paradigm of static versus dynamic competition in antitrust law? As I define it, it's just this rhetorical stance that dynamic competition is about innovation and that antitrust has too long been about enforcing static gains in competition at the expense of thwarting innovation. I don't think we actually believe this, or at least not the people in the room, but there is a generation of scholarship that has made this type of argument starting roughly in the late 1990s. Some may argue that this is some kind of straw man, but it's not actually hard to find pretty recent examples of this argument in the law reviews, and I cite them in the paper. A second definition, or maybe assumption, which is that whatever antitrust economics or whatever antitrust theory is, antitrust law is or should be about applied legal epistemology. I know that's a terrible string of words, but legal academics, people like me, should probably provide insight into how judges, lawyers, enforcement officials make sense of observable facts by crafting legal presumptions and inquiries. But to do that, we have to think about something, which is, what do we really know? What do we know that we know? What do we know that we don't know? Again, apologies to Donald Rumsfeld, may he rest in peace. How do we draw up presumptions and inquiries that respond to what we actually know and what we don't know? How do we operationalize those presumptions and inquiries? For example, what should these institutions do? Antitrust law has to do that because it is applied by actual government enforcement officials, juries, parties to civil and administrative litigation, and their counsel. So the second thing I sort of want to come to is something we've heard a lot about today, which is this idea of innovation, Schumpeter and Arrow. The threshold question in antitrust is usually in this area concerning dynamic competition is what gives us better innovation or more innovation, not that those are necessarily the same thing, monopoly or competition. I read all the papers here, and I counted like 6 of them that recited the Arrow-Schumpeter debate. All of them acknowledge, I think rightfully, that it's unresolved. But there's a question, actually, that we should think about even before the Arrow-Schumpeter question, I think. Robert Bork, in his much cited, much argued about book, even today, The Antitrust Paradox, pointed out, and I'm quoting this, "It is not clear how much progressiveness is desirable." And he used progressiveness as a shorthand for technological progress. He called this definition, or this dilemma, this dilemma, quote, fundamental, unquote. And the reason is, he said, look, it requires the sacrifice of other resources, right, technological progress. I think this is uncontroversial, right? I mean, venture capitalists, private equity investors, they know that if they fund a gamble on a tech breakthrough, there's an opportunity cost versus a safer investment. That's pretty basic to their work, all right? We see this kind of idea a lot. Intergenerational transfers, fairness. Think about the climate change debate, right? You talk to an economist about that, they might ask you or tell you, hey, look, this question, how much do you sacrifice in the present to make Greta's granddaughter's future brighter? Do you satisfy Greta's K through 12 education? Probably not. But this trade-off of present versus future is actually kind of a quandary or a problem for antitrust law. Tom Nakbar, in his paper for this work, which I had the pleasure of reading and seeing him present last fall, talks about Dan Crane's paper on technocracy and antitrust and points out that Crane had this postulate, the third postulate in that paper, which was that antitrust doesn't usually make explicit decisions about how to value one person's interests against another's. I think that was right for a long time. Might not be right now. I think Tom Nakbar writes this as a descriptive matter, that it's no longer true for some people now. I don't think he necessarily thinks that's a normatively good thing, but putting aside that, the point is that even before we start arguing about whether monopoly, competition, or some market structure in between gives us more and better technological progress, if the winner in this debate is the position that monopoly gives us more and better innovation, and this is, again, not just a hypothetical assumption, then we also have to conclude that it's permissible and desirable to trade off current consumer welfare for the gain to future consumers due to innovation. And I'm not saying I know the answer to that, whether that's permissible or not. I'm just pointing out that that's sort of lurking there. Maybe trading off consumer welfare currently in some static sense for future consumers' gain via technological progress, maybe that's okay, right? Maybe that progress happens in 2025, that's next year, or 2030. But what if it's 2050, 2100? Now, additionally, we'd have to think about discount rates and whether they're hyperbolic. So let's put that aside. My point is not about trade-offs and discount rates as my endpoint. I'm using this as sort of a step to another question, which is, I bring this discussion of tolerating monopoly now for more and better innovation later to raise a second point, which is, I think it's important to recognize that this trade-off question of what do we give up now for later, does not come up if the answer, and again, we don't know the answer to this question, if the answer is the arrow side of the debate, right? That competition fosters more and or better innovation. If arrow is right, and competition fosters more and better innovation, then it's all rainbows and unicorns, right? Consumer welfare would be better statically right now and also dynamically in the year 2050 when the innovations being generated pay off, or whatever year. So why do I bring this up? Because then there's an asymmetry in favor of competitive markets. So, to the extent that there's some tie in this debate, it's worth thinking about that. One last set of thoughts. I don't think we're actually ever likely to get a grand unifying theory answer to the Arrow-Schumpeter debate. That's probably not surprising. There isn't one. I did a bunch of work lately or research just to make sure that what I thought was right, that no one's come up with anything in the last 5 years, right, since I had looked at this, because in the last 10 years I've mostly been writing about algorithmic collusion. Has someone come to an answer? No. And then I did what my students would do, because I sort of thought, well, has anyone written something where they say, what are the probabilities, likelihoods, or factors that would ever let us have an answer to this debate? So I asked ChatGPT, and their answer was, we are unlikely to ever have a winner in the traditional sense. I don't know what the traditional sense is, but I guess score one for ChatGPT, because I suspect a lot of us probably feel that way. Also, just as maybe this is humorous, maybe not, right? I Googled and looked through other things, Westall, Lexus, all of the things, the error replacement effect, but I made the mistake of typing in error replacement into Google and forgot the word effect. And it turns out there's a lot of Fletchers, people who make arrows out there in this world. And you got your first results are all for replacement heads for your arrows, which led me down a kind of thought, right, is Google actually burying the arrow replacement effect? Like, if you don't ask for it by name, you don't get it. You get arrow replacement. But then I thought, and Kristen Lamar mentioned, fear and paranoia. I didn't go to business school, but then I said, that's probably fear and paranoia. They're probably not doing that. But here's the thing, right? If we did conclude that competition yielded better innovation, that would actually not just yield to a conclusion that we should enforce Section 2 and pursue monopolization cases. As I'm pretty sure all of us in the room could remember, right? Scalia pointed out in Trinco 20 years ago or so that monopolization is different than a program of deconstructing monopolies. If you actually, since I think most of us probably agree that innovation is the greater source of benefits for consumers, if you actually believed that competition does yield better innovation, that would suggest that maybe Congress or someone should pass a kind of Section 2 prime, right? Not just Section 2, that would provide for deconstructing monopolies. Let's not talk about that. But it's worth noting that there are some implications here to work through. Just in terms of innovation, additionally, there's a tendency to label some firms or ecosystems or industries as innovative, but I think we should have more humility about that. Just because firms have High market capitalizations, obviously that could be innovation, but that could also be rent-seeking, could be other things as well, right? When you look at if you ask yourself what industries or technologies are innovative, we probably no one has talked about things like smart farming and precision agriculture now, but that's a pretty big revolution in what's going on in resource use. Think about someone like Katalin Karikó, who just the most recent Nobel winner in medicine, right? 5 years ago, I bet a lot of people would not have known who she was, right? But you have some black swan event like COVID-19, and that obviously changes that, right? And vaccines, of all things, in pharma were not seen as the most innovative field, right, a few years ago. So just by throwing out these observations, I don't mean to say that all industries, agriculture, social media, vaccine-focused pharma are equally innovative. What I do mean to say is that neither legal academics nor judges nor regulators are likely to be good at correctly labeling some select industries as innovative and therefore worthy of some sort of get-out-of-antitrust jail free card. Some people could point to some metrics like patent filings. That seems like a very inaccurate way to gauge innovation, and one that could also be sort of gamed in some respects as well. And there's this idea that once something becomes a measure, once something becomes a target, it ceases to be a good measure. U.S. obviously is not number one in patent filings internationally anymore, but we don't see a lot of arguments that the U.S. has lost its place in the world re-innovation, or that we should rethink our antitrust policy because of that. And when I say get out of antitrust jail free card, you might say, what do you mean by that? I mean just the hypothetical situation where firms maybe have committed acts that antitrust law would usually consider actionable, but due to prosecutorial discretion or judicial mercy, the firm's role in innovation yields leniency for them. I doubt this happens very much, actually. I don't think that's how antitrust laws are actually enforced. It wasn't, when I started out, actually as a lawyer. But it seems to me it's at least implicit for law professors. It's implicit in arguments that caution against antitrust enforcement in industries deemed innovative. So, as a result, what I argue in this paper is that, and I don't think this is that controversial, is that particular firms, industries, or ecosystems should not necessarily be treated differently and more leniently than others because of claims that they are uniquely innovative. This is understandable in theory, but probably a bad idea in practice. I think it's something you'll wind up, as someone said yesterday, litigating the categories. I would have called it gaming the system, but litigating the categories seems like a better term, so I'll steal it. The edifice of antitrust law as constructed over the past 135 years seems to recognize that. In general, we don't have different antitrust law for different firms, industries, ecosystems. To the extent that we do have differential treatment for a particular industry, for example, it's usually the product of specific, explicit congressional enactment, with a few exceptions. And so coming to AI, there are a lot of articles now about AI. I've written about it in the context of algorithmic collusion. This paper isn't really a paper about AI. To the extent that I discuss AI, it is as a way to think about the points that I've been trying to make above. You don't actually have to look very hard to find claims that AI will cure diseases, yield us real self-driving cars, etc. Sure, maybe. I don't have any reason to say that those claims are not right. But you see claims, admittedly mostly in the business press, not so much law journals yet, that antitrust enforcement should back off and let firms making substantial investments in AI do what they must. For the reasons I've discussed, I don't actually agree with that. I think we should just continue, in terms of antitrust law enforcement, to focus on discrete acts by individual firms and their marginal effects. To come back to my original point about antitrust law as applied epistemology, this focus on individual firms, individual acts, and their marginal effects is actually an approach that enforcers, judges, and lawyers can operationalize. To the extent that I've misread Schumpeter-based arguments for antitrust leniency, and I've read them as something that should be done as opposed to some kind of consciousness-raising kind of conceptual argument. That's Great, I think that's useful, but I don't think it is actually that helpful for lawyers. Thank you, I really have enjoyed this, and I look forward to comments.
Hello, everyone. I'm delighted to be here. I'm Emilie Feyler, a senior consultant at NERA, and also a senior fellow of the lab. So thank you, Professor, for your article. I found it very interesting, and I enjoyed reading it. I think the article does a great job to putting into perspective more than 50 years of everyone's favorite debate, which is Schumpeter against Arrow. And it strikes me to see that 50 years later, the debate is very much still alive and relevant. So in the time I have today, and I know everyone wants to go for lunch, I'll just focus on two aspects of your paper. So you note that innovation is difficult to define, and it's also difficult to measure. I agree, but I would say we can try. And so let me try to provide some insights about how economists think about innovation and how they define it. So first, how do economists define innovation? So if you look at microeconomics textbooks, innovation is defined as the application of new ideas to the products and processes of a firm that leads to increased value for the firm, but also that benefits consumers. And actually, this textbook is taking the example of the iPod. So I remember carrying all my music records when I had my Walkman, and I would say that the iPod was definitely an improvement and made my life easier. And so in this example, even if the new product is not a totally new invention, it's still considered by economists as an innovation because consumers benefit from it. And so they benefit from their product quality. So we think about it that it shifts the consumer demand and it increases consumer surplus. So now how do economists measure innovation? So your article questions really how innovative is generative AI and whether big tech is innovative. Your article argues that it's not enough to assume that because some players were big innovators in the 90s, they still are now. So we can look at a couple of metrics, and that's great because we had the presentation on R&D expenses before, but usually economists look at innovation inputs and outputs. So inputs, you can have R&D expenses or investments, so that kind of measure the firm's willingness and efforts to invest in innovation. And so if you look at R&D expenditures, they are concentrated in a few firms. And those few firms that have been able to be at the 10% spender of R&D, they represent more than half of corporate R&D worldwide. And so all the tech companies spend more on R&D than any other companies in S&P 500. So I think it's important to recognize that overall corporate R&D performance relies only on a handful of firms. So now if we look at innovation output, so you talked about patents. Of course, those are imperfect measures, but here again, the big tech companies are performing really high. They are all in the top 20 ranking of the most patents granted to them in 2023. And now if we look, I think your article suggests that maybe a better measure for innovation would be to look at the difference between ex ante and ex post productivity before and after the new technology. And actually I can think about a substantial number of innovations that were led by big tech over the last 2 decades that have, I believe, increased productivity and consumer surplus, like for instance, the mobile app ecosystems, and the fact that now you can access a lot of services and applications in the same place, or more recently, cloud computing that provides scalable and on-demand computing resources. And your article argues that we're all innovators now, but if you look at those typical measure of innovation, it seems that big tech is actually one of the most or the most innovative industry. And I mean, if we talk about Gen AI specifically, it's not perfect yet, but I do believe that it's going to be able to increase businesses' productivity. There are already a number of studies that show that. So maybe a question for you would be that I agree it's hard to know whether innovation would have been even higher if there were less focus on by antitrust on dynamic efficiency, but to what extent do you think at least attempting to measure innovation would be helpful for antitrust enforcement?
So thank you for those comments. They're really interesting and helpful, and I think they're actually very responsive to the problem that I see, which is that even if we can get to broad, rough justice kind of measures of things like innovation in the way you talk about, it's not clear that lawyers in the enforcement agencies or judges or lawyers representing private parties are well placed to be able to accurately or effectively use that kind of information. It strikes me that that kind of information is the kind of thing that really speaks to lawmakers, for example, in trying to inform the writing of statutes, the modification of statutes, perhaps giving authority for regulation or taking away authority of regulation. I think it's part of it is to me, when I bring up some of these questions like the threshold question, trade-offs, it suggests that some of these discussions, and they're very important, and measuring these things is very important. I think economists do tremendous work in these areas. I don't even understand how you could think you could answer these questions, but they persist, right? Like I agree with ChatGPT. I don't think there's going to be an answer in the traditional sense of a winner in that debate, but it's great that people are trying, and it does inform us, and it would be useful, I think, I think it's useful for policy makers, like legislators. I don't think it's particularly something that lawyers can or maybe should be trying to sort of operationalize. Terrible word, but I use it too much. And so I think what you're saying is actually probably good, but not something we as lawyers can easily use on a regular basis. I do want to say one thing, and it may or may not be totally responsive. You started out with this discussion of the iPod. And sure, I owned an iPod, but like a lot of people in a small window of time, I also owned something called a Rio, which was made by a company called Diamond, that also stored a tremendous amount of music in a small space. It was actually cheaper than the iPod, and it came first. What ended the Rio was that they did not have the power to overcome the copyright industry, right? They were sued into oblivion and taken off the market. Steve Jobs, in connection with the iPod and also the iPad, if you think back to the ebooks case, in both of those situations, he had a market power or a market position that allowed him to push back on the copyright industries. I think that's actually an interesting problem too, right? Because some might say, well, wow, maybe market power is good, but is that innovation, the ability to overcome an entrenched industry that is itself potentially collusive? I don't know. That's a tough question. I don't know. And I think, did I respond to the things? All right. Well, thank you. Thank you very much.